What legal rights are needed to adapt books to film? If you have ever wondered how a book becomes a movie, you are not alone. The journey from page to screen involves several important legal steps. Let's break down the legal rights needed to adapt a book into a film. First and foremost, the key legal right required is the film adaptation rights. These rights are part of the broader copyright held by the book's author or copyright owner. Securing these rights is essential. Without them, any attempt to adapt the book would violate copyright law. The first step in this process is understanding copyright ownership. The author or copyright holder has exclusive rights to reproduce, distribute, and create derivative works from their book. This ownership is often established through registration with the Copyright Office. While registration is not mandatory, it helps with enforcement and licensing. Next, filmmakers typically start with an option agreement. This is a time-limited agreement, usually lasting 12 to 24 months. It grants the option holder the exclusive right to purchase the film rights within that timeframe. This allows studios to develop projects and secure financing without immediately buying the full rights. If the studio decides to move forward, they will sign a purchase agreement for the film rights. This contract must clearly outline which rights are being sold, such as motion picture, television, or streaming. It should also specify the scope and limitations of those rights, including territory, duration, and formats. Financial terms, such as upfront payments and royalties, must be included as well. When adapting a book, it is important to consider derivative works rights. Film adaptations are considered derivative works under copyright law. The right to create these works is held exclusively by the copyright owner unless licensed. The adaptation must transform the original work into a new medium, and the contract must clarify which elements are included. All rights transfers or licenses must be in writing and signed by the copyright owner or their authorized agent. Oral agreements are not sufficient for transferring adaptation rights. It is also essential to consider additional licensing. The film rights license usually covers only film and television adaptations. Other adaptations, like stage plays or audiobooks, requiring separate licenses. Authors and producers should clearly define these rights in contracts to avoid disputes. Lastly, authors can negotiate terms to protect their work's integrity. They may requiring that diverse characters remain as represented or that key themes are preserved in the adaptation. These stipulations should be explicitly included in the contract. In the realm of entertainment law and media rights agreements, these legal rights shape how intellectual property is controlled and monetized. Properly structured agreements help prevent disputes and ensure adaptations proceed smoothly within the legal framework governing intellectual property rights.